Real parties and interests are as which move the court under Federal Rule of Civil Procedure 62, Rule 62, stay of proceedings to enforce a judgment, and its inherent authority to stay the order entered in this action on May 27, 2022, pending movement's petition for a writ of certiorari argument. In its May 27 order and accompanying opinion, this court decided novel procedural and substantive issues concerning the validity of the United States Patent and Trademark Office, seeking as intellectual property trademark brand to preserve the status quo. While moving appeal those issues, the court should stay its order and enjoin enforcement of the auxiliary process. Absent a stay, movements will suffer irreparable harm from the protection of their private information. By contrast, a stay will cause only minimal temporal harm to the government, and the public interest will be served by the preservation of movement's privacy pending full appellate consideration of the substantive issues this case presents. A. The standard governing a stay pending appeal. Courts consider four factors in determining whether to stay or grant stay pending appeal: whether the stay applicant has made a strong showing that he is likely to succeed on the merits, whether the applicant will be irreparably injured absent a stay, whether issuance of the stay will substantially injure the other party's interest in the proceedings, and where the public interest lies. A witness cannot refresh his memory as to conversations by reference to memoranda copied by himself from notes made by him at the time of the conversations. As we have often repeated, states have no power to retard, impede, burden, or in any manner control the operation of the constitutional laws enacted by Congress. We affirm the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. Many courts view the first two factors as sliding scale, with the greater the harm to the movements requiring a lesser showing of the likelihood of their success or appeal. Injunction granted pending appeal, where appellant makes strong showing of irreparable harm. Even though Court of Appeals does not suggest the appellant has a winning case or even a good case, the necessary level or degree of possibility of success will vary according to the court's assessment of the other state factors. The composition of the federal judiciary affects whether courts will exercise restraint and apply the law or create policy change through judicial activism, which in turn directly impacts public trust in the courts. It also impacts the judiciary's vital counter-majoritarian role of checking the political branches, ensuring the constitutionality of laws and the lawfulness of government action. Courts have found the for-cause removal protection to be implicitly present in those statutes that have set a specific term length for commissioners. Presidential review of independent regulatory commission rulemaking, explaining the relevance of the meaning known to ordinary citizens in the founding generation. The same standards apply to injunction pending appeal, thus the court need not differentiate between movements' requests for a stay pending appeal of this court's May 27 order and their related requests for an injunction pending appeal of the auxiliary process. We begin by analyzing the original meaning of Article 2, Section 2, Clause 2 of the United States Constitution, the Advice and Consent Clause of the Appointments Clause, because the advice and consent process is the vehicle by which not only our Supreme Court, but all inferior Article 3 courts are populated. This analysis carries profound implications. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by the citizens of another state, or by citizens or subjects of any foreign state. Article 3 of the Constitution invests the judicial power of the United States in the federal court system. Article 3, Section 1 specifically creates the U.S. Supreme Court and gives Congress the authority to create the lower federal courts, 28 U.S.C. 2201, 1982. This note assumes that the same judicial boundaries apply whether the compliance seeks an injunction and declaratory judgment or both. Support exists in the case law for several positions as discussed below. The microstrategy analysis demonstrates that a stay and injunction The Supreme Court may enter questions of law certified to it by the Supreme Court of the United States, the Court of Appeals of the United States, or of the District Court of Columbia. The United States District Court when requested by the certifying court if there are involved in any proceedings before the court questions of law of this state which may be determinative of the cause then pending in the certifying court as to which it appears to the certifying court there is no controlling precedent in the decisions of the Supreme Court. Cases involving constitutionality of federal or state statutes, a party who draws in question the constitutionality of any act of Congress in any proceeding in the Supreme Court to which the United States or any agency thereof or any officer or employee thereof as such officer or employee is not a party upon the filing of the record or assumed thereof if the questions are raised in the Supreme Court shall give immediate notice in writing to the Supreme Court the existence of said question. The Sixth Amendment issues that Section 1, the Sixth Amendment rights in matters involving federal law, expresses that state courts are bound only by decisions of the United States Supreme Court. Federal appellate court decisions are persuasive only. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at times stay receive their services a compensation which shall not be diminished during their continuance in office. Federal laws, immunity laws in state courts. An example of the former circumstance is the operation of Federal Immunity Acts tend to preclude the use in state courts of incriminating statements and testimony given by a witness before a committee of Congress or a federal grand jury, because Congress, in person with paramount authority to provide for the national defense, is complemented by the necessary and proper clause, is competent to compel testimony of persons which is needful for legislation. It is competent to obtain such testimony over witnesses' self-incrimination claim by immunizing him from prosecution on evidence thus revealed not only in federal courts but in state courts as well. On the doctrine of dual federalism, see the commentary by the originator of the phrase. Reconcentrating witnesses, the non-delegation doctrine constrains Congress's ability to delegate its legislative authority to executive agencies. The Constitution provides that all legislative powers herein granted shall be vested in the Congress of the United States, and we have long insisted that the integrity and maintenance of the system of government ordered by the Constitution mandate that Congress cannot generally delegate its legislative power to another branch. Power of appellate court not limited. The provision in this rule do not limit the power of the appellate court or of a single justice thereof to stay proceeding during the pendency of an appeal, or to suspend, modify, restore, or grant an injunction during the pendency of an appeal, or to make any order appropriate to preserve the status quo or the effectiveness of the judgment subsequently to be entered. Certiorari should also be granted because the question presented raises important questions of federal law, the proper interpretation of an often invoked federal statute, establishing the parliament exception to the general rule that orders compelling grand jury testimony or denying motions to squash grand jury subpoenas are not appealable final orders where an individual whose information is sought from a third party raises a constitutional challenge to the government request. Rule 9, second or successive motions. Before presenting a second or successive motion, the moving party must obtain an order from the appropriate court of appeals authorizing the district court to consider the motion as required by 28 U.S.C. 2255. These removal mechanisms include the federal officer removal statute. The ratio M is assumed to be continuous, which may be the case if the number of legislators per district varies.